They're back. Remember the Brunson v. Adams case? This case that's behind me? This is the famous case that maintained that former Vice President Pence, Vice President Harris, President Biden, then Speaker of the House Nancy Pelosi, and almost 400 Congress members should all be removed because they certified the 2020 election without investigating the allegations of fraud. That petition was denied by the Supreme Court in early January. No surprise there. Well, that case is back. Or at least a petition for rehearing was filed at the end of last month at the Supreme Court and is now going through a process called a distribution for conference. A conference is the process where the justices sit down and discuss whether a case should be heard or not, and that's exactly what had happened to the Brunson case during the first filing at the beginning of the year. And you can see in this docket entry all the way to the bottom where a conference for the original petition was scheduled on January 6th, and then obviously was denied. The new conference is scheduled for February 17. What's going to happen this time around? Here's my opinion. The case was dismissed by lower courts twice before. It was then petitioned to the Supreme Court. The Supreme Court rejected that petition. That means it isn't likely at all to hear the case this time around for two reasons. Number one, the Supreme Court isn't likely to hear a case that it rejected before. It just doesn't do that. And number two, let's be honest, the case is pretty ridiculous to begin with. But according to Rule 44 of the Supreme Court rules, a petition for a rehearing can be filed within 25 days of rejection, and that's exactly what the petitioners have done. We'll see what the conference decides, but if I were Brunson, I wouldn't be holding my breath.